of reason and cooperation.
Our little school got world-class cricket equipment and training.
Binding our stories together, past, present, and future. The Tokyo Cement Group.
Check. Check. Can I be audible? I'm not leaning forward. Yeah, sure. One of the focal points of any closing ceremony is a panel discussion on timely topics. And this year's panel discussion is one that has a topic which has been hotly contested. Is it audible? Now I'm not leaning in. Now I'm not leaning forward. evening, ladies and gentlemen. We are about to commence our proceedings shortly, so this is a warm invitation for all of us to take our seats. Thank you. Distinguished dignitaries and invitees, councils, arbitrators, students of the law, ladies and gentlemen. A very good evening to you all and welcome to the award ceremony and closing ceremony of the Victors Moot 2023. The H.V. Pereira Queen's Council Memorial International Commercial Arbitration Moot is the first of its kind in Sri Lanka. And this year, we're very proud we very proudly celebrate its 6th reiteration. This ceremony takes place at the conclusion of days of intense competition, which followed months of training, research, analysis by teams, organizers, and arbitrators alike. So directing our attention to the screen, we can now catch a deeper glimpse of the true nature of the Victors Moot 2023.
Arbitration's journey begins in antiquity, from settling trade disputes in ancient Mesopotamia to modern corporate resolutions, it has woven itself into the fabric of human society. A tool for justice, a symbol of reason and cooperation. In our interconnected world, the importance of arbitration grows. It bridges gaps, speeds up resolutions, and fosters growth. But what about places like Sri Lanka, where justice often faces delays?
Arbitration has emerged as an efficient and cost-effective alternative as the process is typically faster, less formal, and can be tailored to parties' specific needs. Additionally, it's conducted privately, maintaining the confidentiality of both the parties and the disputes, and that's a quality that can be especially valuable in sensitive business matters. By facilitating quick resolutions and maintaining the principles of justice, arbitration not only promotes business confidence, but also stimulates economic development. Its flexibility allows for a more nuanced approach to complex legal issues, and its accessibility ensures that even smaller businesses can seek redress without the fear of extended legal battles.
Every year, we see that there is a massive influx of litigation coming into the court system of any country, and this is not a characteristic that is only unique to Sri Lanka. And therefore, the legal system or the court systems of most countries have not been able to fulfill the needs of the business communities of the corporate.
Sri Lanka's economy thirsts for a quick, fair legal system. Being an effective form of alternative dispute resolution, arbitration is an elixir but faces challenges like the lack of awareness and limited practice. This isn't just a Sri Lankan issue, it is a global issue. How do we face this challenge? By empowering the next generation of legal minds, by fostering a global community, by giving life to theory through practice. And so, the H.V. Pereira QC Memorial International Moot competition was initiated, a convergence of learning and experience, bridging the past's wisdom with the future's innovation. H.V. Pereira, a name synonymous with justice and integrity, inspires our cause. His legacy is a compass guiding us towards a brighter and fairer future. Our vision transcends competition. It is a calling to elevate arbitration to enable swift dispensation of justice and to make justice not just a concept, but a lived reality. This is our call to action. Join us, be part of the movement. Shape a future that's just, connected, and harmonious.
Each year, the Victor's Moot is known to provide an outstanding platform for the test of legal research, analysis, oral and written advocacy, as well as giving law students, both domestic and foreign, a chance to really connect with each other. To receive us all with a few words of warm welcome, I would now call to the podium the Deputy Principal of Sri Lanka Law College, Mr. Shehan Pereira, Attorney at Law.
Good evening, ladies and gentlemen. A very good evening to you. There's a lot of suspense in the air today. I was having a chat with the giants in the field, and I hear that the results are about to be announced. So keep your fingers crossed. Yes, it's you and you. Irrespective of who's won and who has lost, the experience and the exposure will stand you in good stead. I remember the beginning of this program, ladies and gentlemen, in 2018, how it began with all these sleepless nights, the long lists of people and things to do, the arguments that students had. And from there to this, in a few years, is a great achievement. So I congratulate Praveen and his team, the very able team of the Moot Society. They always do a very professional, fantastic job, which also is shown in the attendees today. We have the giants in the field. We have people like Her Ladyship Justice Tilakavardhana, who always uplifts any event she attends. adds a touch, or good dose, should I say, of glamour. We have Dr. Kanagiswaran, President's Counsel. If you have heard it from him, you have heard it from the horse's mouth. When it comes to arbitration, there is no other name that is synonymous with arbitration in Sri Lanka. We also have people like Mr. Avindra Rodrigo PC, Mr. Chandaka Jayasundara PC, and a host of others. And the event is also graced by the President of the Bar Association of Sri Lanka, Mr. Kaushal Navaratnam. Thank you so much for being here. This, ladies and gentlemen, shows how far this event has come. The prestige, the glamour, and all the learning that it brings with it. I'm so proud of the Moot Society, and I must also thank the past presidents and the chairs of this event from 2018 onwards. It is on your shoulders that this event has been built and brought to this level. So all the hard work that you put in has been bearing fruit and will continue to do so. I just want to share with you a little experience that I once had several years ago. We were in Bahrain. I was with some of the stars at Law College. It was the very first Moot team, Viz Moot team, that was attending the Viz Moot, and they were given special training in Bahrain. So we were at the hotel restaurant, and there was a young lady who was serving us, and she saw us, and perhaps by the color of our skin, she said, India. And we proudly said, no, miss, we are from Sri Lanka. And she said, oh, Sri Lanka, I have boy in housekeeping Sri Lanka. And to our dismay, we knew what she meant. Now, not to think less of any profession or job, but we were known in that part of the world for holding blue-collar positions, jobs. So this was the perception. We had been stereotyped as blue-collar workers. And here I was with a star-studded team, and they have already begun to shine in their respective fields. Now, why I'm saying this is because when you participate in an international competition and you have the opportunity to meet all the leaders in their fields, you are not only an ambassador of yourselves, but you are an ambassador of your countries. And it is through you that others see the country that you represent. So I think the teams that have participated in this competition, this installment, I'm sure you are very well aware of it, and wherever you go, that you're flying your flag high, and that you are changing the perceptions, maybe negative perceptions that people have about you or your countries. So remember, when you represent your country, always to keep your flag flying high, not only for yourself, for your country, for your institution. Our students at Law College have always shown a lot of professionalism in organizing these events, and that is why we are blessed with all our seniors, all these distinguished guests coming forward to assist us. We also have Dr. Asanga Gunavansa, who's come back again as a lecturer and who's part of the Board of Studies, who helps us so much. And the students are blessed to be able to learn from these greats. I won't take a long time speaking to you. I know that we have other business to conduct today, but I want to end by saying I'm very proud of the Moot Society of Sri Lanka Law College and all those who have helped out in numerous ways in the past to make this event what it is today. Thank you very much. Have a glorious evening.
Thank you very much, sir. One of the key factors of success of any H.V. Pereira QC Memorial Moot are the individuals that take that step, take the initiative to learn something new, to participate, and not only participate in that year, but encourage all those who come after them to participate as well. And we will now be introduced to all the teams that took part in the 2023 Victors Moot. Regardless of the outcome that is to be held after the awards ceremony, we would like to thank each and every one of these teams, some of who are present here physically and others digitally, for making the Victors Moot truly what it is. 21 teams participated, and we thank them for their contribution in making this event an absolute success. I would now like to call to the podium the Principal of Law College, Dr. Atula Patinayaka, for his remarks.
Good evening, everyone. Your Ladyship and the President's Council, and also the President of the Bar Association, distinguished members and students and participants. Now, Victors Moot, I don't have to give you an introduction because the previous speaker and the video clip you have come to know everything that you need to know. As it says, Moot competition, this Victor Pereira QC Moot competition started in 2018. And I know after that, we were not being able to do it successfully due to pandemic, but this year we have started it again in a more glamorous manner. The vision of the Victors Moot is to provide the students the ideal platform to engage in mooting, and also it is a kind of networking as well. I always believe moot teams are the ambassadors of the law school. And during my tenure, that is what I want to establish, that our moot team will be the #1 team in Sri Lanka and also in Asia. And we can achieve that. Praveen and his team, I should congratulate, very recently did extremely well in a mediation competition. It is done through Moot Society, And I should thank, I don't think he has come here, Mr. Janak Basuri and Miss Anuji Kannangara. They did extremely well, and I think we have found a fantastic combination of lecturers who can guide us to achieve this target. Now, I don't want to take too long. As you all know, we are celebrating 150 years next year. And Law College will give the fullest support to our Moot team to organize international Moot competitions and make Law College a known institute in Asia. I could remember when I was at Deakin University, I'm not saying I could proudly say we started Alfred D competition about 4 years ago. We had only about 4 participant institutions at that time. Now it had become the biggest mooting competition in Australia and one of the biggest in the world. So thank you very much. I want to congratulate the participants, so the Moot Society, for making this event a very successful event. And next year, I will see you all. Wish you the very best. Thank you.
Organizing a comprehensive moot court competition of this nature requires a great deal of logistical management as well as resource management. And we would now take this opportunity to thank our valued sponsors. Alongside the Tokyo Cement Group, we would also like to proudly say that the Victors Moot this year is proudly supported by the Asia Foundation, the Institute for Commercial Law and Practice, Mycola, Pepper Street, the Nine Wells Wellness Center, and the International Alternative Dispute Resolution Center. Can we all give our sponsors a big round of applause for all their support? One of the focal points of any victor's closing ceremony, it's almost a tradition, is a panel discussion on a timely topic. We've had many over the past years, and now it is time to familiarize ourselves with the content of this panel discussion.
Across the world, where tradition meets the tide of change, one arena remains consistently crucial: the sphere of legal discourse. The legacy of dispute resolution, irrespective of borders, is both deep-rooted and dynamic. Arbitration, a method where disputes are settled outside the courts, a structured approach where an arbitrator delivers a binding decision. Contrasted with mediation, a more fluid dialogue. Here, an impartial mediator aids parties to arrive at a mutual resolution, non-binding but often transformative. Today's global stage amplifies a resonating question. In this landscape of choice, where does the future lie? Arbitration, mediation, or a fusion of both? Across the globe, alternative dispute resolution emerges as a hopeful solution to legal conflicts, outpacing traditional litigation with its efficiency. As mediation's collaborative approach gains ground against the traditionally dominant arbitration, a question surfaces. In an era favoring mutual dialogue and understanding, is mediation poised to be the world's new preference in dispute resolution? Today, the brightest minds of Sri Lanka's legal fraternity will navigate this complex terrain, guiding us through nuances, potentials, and the road ahead. As we delve into this discourse, know that you're witnessing more than a discussion. It's a juncture of decisions that will shape our legal destiny. Prepare yourself. The curtain rises on a pivotal dialogue in Sri Lankan alternative dispute resolution. Is mediation a better alternative to arbitration?
Now that we have come to identify the topic of this year's panel discussion, it is now time for us to get to know our panelists, our esteemed panelists and moderator. Firstly, we have Justice Shirani Tilakawardena, retired judge of the Supreme Court of Sri Lanka. In Sri Lanka, she is considered a trailblazer for women in law, achieving historic milestones, becoming the first female state councillor, the inaugural woman judge of the High Court, and the first female justice of the Court of Appeal, president of the Court of Appeal, judge of the Supreme Court, and the acting Chief Justice as well. Justice Tilakawardena's influence extends globally, championing gender equality, justice, gender education, and child rights. Her ladyship's significant impact on child rights includes drafting guidelines for child victim and witness testimony adopted by the United Nations for the International Criminal Court. Her ladyship has led advocacy efforts, conducting workshops on gender issues and child rights for judges. Justice Tilakawardena's affiliations include key roles in organizations like the International Bureau of Child Rights, the Child Protection Authority, and the Asia Pacific Forum for Gender Education for Judges. Serving on international advisory boards, her ladyship has shared expertise and consulted with the Sri Lanka Judges Training Institute. It is also to be noted that her ladyship has functioned in the Consumer and Narcotic Division of the District Attorney's Office in Fort Colorado, the United States of America. And recognized for Justice Tilakawardena's achievements, Justice Tilakawardena has received honorary degrees from Williams College and Smith College. We also have Dr. Kanaganayagam Kanageeswaran, President's Counsel. Dr. Kanageeswaran is an attorney at law as well as a barrister at law at the Lincoln's Inn. He specializes in diverse fields such as aviation, banking, corporate law, and more, and is well regarded for his involvement in significant legal cases in Sri Lanka's history. A pillar of the legal community, President's Counsel Dr. Kanageeswaran's contributions are not confined to the courtroom. He has served as a member of the Law Commission of Sri Lanka and held directorial roles at the Law and Society Trust and the Institute for the Development of Commercial Law and Practices Arbitration Center in Colombo. His expertise has been sought in advising on new legislation and as chairman of numerous committees. His commitment to legal education is demonstrated through teaching roles at esteemed institutions such as the Faculty of Law, the University of Colombo, and Sri Lanka Law College. President's Counsel Kanageeswaran has also played roles in corporate governance and authored books, articles, and treatises on company law. Dr. Asanga Gunawansa is our next panelist. With over 25 years of experience, Dr. Gunawansa holds a PhD in law from the National University of Singapore and a Master of Laws in International Economic Law from the University of Warwick. He currently leads the Colombo Law Alliance, specializing in foreign investment law, arbitration, construction law, commercial law, environmental law, and legal aspects of sustainable development. Dr. Gunawansa's influence also extends globally, advising the independent redress mechanism of the Green Climate Fund in Korea, chairing the Sri Lanka International Arbitration Center, and contributing to the Council of Legal Education in Sri Lanka. He is a visiting professor at the University of Moratuwa and an international research associate of the Institute of Water Policy at the Lee Kuan Yew School of Law at the School of Public Policy at the National University of Singapore. His experience includes working for the United Nations Compensation Commission in Geneva and the United Nations Relief and Works Agency in the Middle East. He taught construction law, water law, and environmental law at the National University of Singapore, and driven by his passion for legal education, he focuses on areas such as construction, alternative dispute resolution, infrastructure development, international environmental law, and climate change's legal and policy aspects. And as of very recently, has once again joined the faculty at Sri Lanka Law College to teach the subject of arbitration. Ms. Shihara Varia, attorney at law, is an impactful contributor to arbitration and law, earning a bachelor's degree in law from the Open University of Sri Lanka and a master's degree in international trade law from the University of Wales. She has further solidified her expertise as an accredited mediator from the London School of Mediation and is a fellow of the Chartered Institute of Arbitrators, UK. Her roles reflect her dedication to the legal landscape. As Honorary Secretary General of the Director of the Arbitration Center for the Institute of the Development of Commercial Law and Practice, as well as the Director of the Chartered Institute of Arbitrators branch in Sri Lanka. She is a driving force in advancing the practice of commercial arbitration in the island. She has held the position of partner at the prestigious legal firm FJNG de Serum for over 20 years, where her commitment to excellence shines. Additionally, she imparts her knowledge as a lecturer in the diploma course in arbitration at the Institute for the Development of Commercial Law and Practice. I will now introduce you to our moderator for this session, Mr. Rehan Almeida, attorney at law. Mr. Almeida is a member of the Chartered Institute of Arbitrators and is a private counsel specializing in commercial and corporate law with a specific focus on company law, maritime law, intellectual property law, banking, and arbitration. He holds a bachelor's degree in law from the University of London and a master's in law in computer and communications law from the Queen Mary University of London. He also was a lecturer for undergraduate and postgraduate course modules on business law and maritime law at the National School of Business Management. He was also a visiting lecturer at the Institute of Chartered Accountants in Sri Lanka for the external MBA program for the University of Southern Queensland. He is currently a visiting lecturer at the American National College for the postgraduate LLM module in the subject of international dispute resolution. He has also served as the convener of the expert panel on maritime law reform, appointed by the Ministry of Justice. He served as a committee member of the legal subcommittee on the analysis of the laws relating to the establishment of a maritime disaster management unit, as well as the committee appointed to recommend a plan of action in relating to the claims arising out of the MV Express Pearl disaster, approved by the Ministry of Justice. Ladies and gentlemen, after those very lengthy introductions, can we please give a warm welcome to our esteemed panelists and moderator. I now invite our panelists and moderator to take the stage. We would also like to note that we do have a virtual audience joining us on Zoom and Facebook Live. So now, to begin this panel discussion as to whether mediation is a better alternative to arbitration, which is a hotly debated topic nowadays, I would now like to hand over the proceedings to our moderator, Mr. Rehan Almeida, attorney at law.
Check. Thank you very much, and thank you for that very generous introduction as well. It is indeed an honor and a pleasure to be back in forums such as this. It takes me back to very fond memories of being back at law college and my mooting days. I would say I managed to gain a lot of experience and actually knowledge on the law through mooting. One of the most profitable experiences for me. So you are living your best lives and best days when it comes to your legal education through mooting. So enjoy the time, learn. My suggestion is also to moot. I've noticed that members of Sri Lanka Law College in the Moot Society tend to organize more than actually moot. So it's definitely something that you should stick at it in that sense. The topic for this evening is indeed a very relevant one at this stage. I think it's safe to say that Sri Lanka, when you talk about the ADR landscape, is at a bit of a crossroads. It's happening on a global scale as well, where there is a distinct and noticeable shift from arbitration towards mediation. There's a definite push when it comes to mediation. It's happening in Sri Lanka also. So the question then is it an and/or situation? Do we back mediation? We have had, I think it's safe to say, a bit of a jaded experience with arbitration also. So what should our approach be? And how should we try to really push ADR as a viable option? We have 45 minutes for this discussion. It's not a lot of time, but we'll see what the best time management that we can do. You have one of the best panels, I would say, for a discussion of this nature. You have the judicial perspective. You have the brains behind the current arbitration regime, and you have the brains behind the reforms that are being brought into arbitration as it is, and the institutional perspective when it comes to both mediation and arbitration. So you have the knowledge before you. We'll start the discussion off. Please do engage discussion over the next 45 minutes. Her Ladyship Justice Tilakawardena, but it is her character, I think, that she said that let's start with the topic that we are more familiar with. Let's talk about arbitration to begin with, because the victor's moot is on arbitration, to be given to you by Dr. Kanagiswaran. Escape in Sri Lanka, I think it's safe to say that we are at that decision-making point as to whether arbitration has worked. What is
arbitration? Been around for a long time. Its success or failure does not depend on the legal framework. It depends on the players who play the game of, and consequently it has been a drag. It has not worked as it ought to have. Many years ago, maybe 20 years ago, I was asked to write an article about arbitration as it worked. What I said there still holds good. They are somewhere in the Bar Association Law Journal, I think. So that is the state of the arbitration in Sri Lanka today. But we still have a long way to go. As I said, you would have seen the moot. There is a lot of discipline, a lot of thought going into it and preparation. I don't know whether it's happening in the arbitration. It's a long time since I've been an arbitrator. I've been an arbitrator only just one arbitration. I was nominated by a Queen's Counsel as a sole arbitrator. As it happened, my award was against the Queen's Counsel, and we were very upset with it. And it was challenged in the district court, but they upheld the award. After that, I never went in as arbitrator. Sri Lanka is a very small place. Some people go around. So I have never been an arbitrator since then, though I have participated in such events in foreign countries. Now, as to the present status, I think Justice Tilagadina is the most popular arbitrator going. She might be in a better position to tell us. She has been a stickler for management and always has been punctual. She has a very disciplined mind. Practices we adhere to, which you have been trained and taught about in lectures, but you never see that in practice. So the future depends on you, how you will set about doing this arbitral process. It's a beautiful process. When it's properly done, it benefits the commercial community, it benefits you, and you move from one arbitrator to another. And as I said, Madam will tell you all about it.
I kind of feel a real traitor this evening because I was specifically, first I was delighted to see there's a gender balance on this after a long time. Because there's an audit being conducted all over the world, and this augurs well for the present and the future. But I was told very specifically by our leader for this, the fearless leader we have, that I had to speak on mediation together with Shehani, and I don't know how it would look if I actually crossed over. Perhaps Mr. Gunavansa, you have to speak on arbitration, and the topics were divided in that way. So I kind of can't abandon, of course I've been doing arbitrations and I love arbitrations because it is something you can really manage, and you don't, though it's relatively expensive, if you handle it well, you just have the direction order, everything is sorted out, you don't even have to sit for issues, you can do it. Now we have virtual contacts, so we can sort that out virtually. And also we can even do Zoom connections. So during the COVID time, we had Zoom with different countries, Ghana, England, Sweden. I mean, it was wonderful. So we did not stall. We went working right through that period. And I do know somebody who's, I think, equally good or even not better than me, Mr. Gunavansa, who has lots of practice, especially in construction arbitration, which is where it's working at its best. And I think he's had international practice as well as local practice, as all of us have had. But I think I'll move it over to him so that I don't tilt the balance on mediation, because it's really, we were told the two of us are going to speak on mediation. So let me hand it over to Dr. Gunavansa. Would you take over from there so that
Thank you, Ladyship.
Yes.
A very good evening to all of you, and thank you very much for inviting me to the organizers. So I would agree with everything that Dr. Kanageshwaran said, and what I would add is I don't think arbitration is getting unpopular because there is no way of walking away from it. Because if you look at the type of commercial contracts that we enter into today, a good number of commercial contracts are entered into in Sri Lanka by government institutions with foreign entities, foreign lending institutions, and all these agreements have arbitration clauses. In the construction field, again, no way of walking out of it because the practice is to adopt standard form contracts either introduced by FIDIC or introduced by the Construction Industry Development Authority, and they have arbitration clauses. Then when it comes to big corporate entities, yes, they are not satisfied with the current practice for a number of reasons. We will need a full day session to talk about all those reasons. But having said that, if the other party insists and if they see that it is a more prudent option to go for arbitration instead of going to court, they still agree. So I wouldn't say that arbitration is unpopular if you want to know the status of arbitration today. But having said that, things could be better. So when we speak about arbitration, the people in the arbitration community, I have some colleagues here like Mr. Rodrigo and Mr. Jayasundar who have great practice in the area of arbitration. They would also agree. The general popular complaints are about infrastructure insufficiencies in Sri Lanka. Building facilities, I think we are fixing it now. And then support services when it comes to having proceedings ready and so on. That is only one aspect of it. It's very crude to say this, but I call arbitration Gedara arbitration in Sri Lanka. The reason for that is the practice among Sri Lankans is to, not only the lawyers, but most arbitrators, Justice Tilakavardhana excluded, prefer to have arbitrations around 4:30 in the evening and finish around 6:30. So those who go to court finish their court practice, have lunch, maybe a little nap, and come in the evening. And the senior arbitrators, most of them being retired judges, have their lunch and afternoon nap and then come at 4:30. And there very little work that you can do between 4:30 and 6:30 in an arbitration. There have been times that we have been struggling. There's one arbitration that Mr. Rodrigo and I are doing. We are trying to convince the arbitrator, let's sit on Saturday, let's sit on Sunday, let's start at 10 in the morning, let's go on till 4 p.m., we can finish this within a month. But we have not been able to, do that. So if arbitration is to really work in Sri Lanka, and now there is a lot of talk about trying to promote Sri Lanka as an arbitration hub. I think there's a lot of potential for us to be arbitration hub in South Asia. But if you have to go down that route and achieve that status, then the whole arbitration culture has to change. Knowledge of arbitration, I think we can match anybody in Asia. Maybe perhaps the rest of the world. So it's not the knowledge, it's the culture that has to change.
Thank you very much, sir. I think that is the key takeaway, and it's the comment that we've been hearing over the past few years, that it's not so much the what we have in place presently, which is the issue, it's the manner in which it is being used, and the culture essentially. So that is the point hopefully we can get towards. But let's shift our attention then towards mediation, the other side of the coin of our discussion today. May I bring you in, madam, at this stage to talk us through mediation in principle, what it amounts to, what the practice is, and if you can also look at principally the advantage, disadvantages with the process in that sense.
Of course, the easiest thing to do now is to tell you, go to ChatGPT and punch in, and you will all get 11 positives and 10 negatives and balance it. But that's not the way we are going to do. I really wish I would be given the opportunity to talk to you about AI and the other generative AI and the other things about the algorithms, the big data and all that, because it's going to be a very large role in your lives. And for us as judges, as law students, as lawyers, we are allowing the world to change on being led by the technocrats, by the technology. We are not asking the questions. Is it constitutional? What about protection of property rights, virtual rights which are being absorbed as big data? What about copyrights? What about transparency? What about open justice? What about the different fair and open justice that we are rooted in? So those are things I hope you will do. I'm at the moment trying to develop a toolkit on all of these new things so that we can teach the judges, the younger judges, as they come in, and it's a lot of work, but it's also very, very productive. And it is in that background that I want to speak to you, because that is your future. Please note that I said it today, that you are going to get caught up very soon in the whole vortex of this new technology that is coming out. Don't lose your ground. Be lawyers, analyze it, and move forward with it. Go with it. There are lots of positives, but also with critical thinking. And always look for logic and reason when you proceed forward. So my topic today, and Shani's topic, is also advantages of mediation over arbitration. Because that is my mandate this evening, I will talk about that. But do realize that I find that while mediation and arbitration are alternate dispute resolution methods, it definitely provides more advantages over litigation. Almost having served 50 years in work in the courts, definitely it's ahead of litigation. The horrendous stories I'm hearing about delay, the COVID delays that we have, and how judges are almost being pushed beyond reason to try to manage the sheer volume of work. I think this is something we know is going to be part and parcel of our future dispute resolution. So mediation stands out for its distinct methodology and advantages, because mediation is a process wherein the parties meet with a mutually selected, impartial and neutral person who assists them in the negotiation of their differences. You see, disputes arise because people are different, situations are different, and there is conflict. So mediators actually help parties resolve conflict using a variety of styles and approaches. We are often given the Singapore style of mediation, but there are different styles, and very often it is how can you assist in resolving a dispute is the end objective. But the mediation leaves the decision and power totally and strictly with the parties. It is called party autonomy. I'm sure you're going to deal with that, right, Shan? So arbitration and mediation are different processes with different purposes. The fundamental difference lies in who makes that final decision. This is usually a neutral third party in arbitrations or the parties themselves in mediation. In contrast to arbitration, in mediation, the third party's neutral role is merely to facilitate negotiation. And the parties themselves make the final decision as to how to resolve the dispute. They call it the win-win situation, because unlike in any other dispute resolution, one party does not go away saying either it is unfair, this is wrong, and generally they'll end up saying either the judge or the lawyer was bribed, because 50% of the people walk away unhappy. So under mediation, it is an interest-based and party-centered model of mediation. I'm especially going into a few details because I do know there are young people who have probably walked into this hall today not even knowing what mediation is. Of course, the giants are here, those who have taken part in today's arbitrations, who are talking about mediation. But this is an important facet, and I have no doubt, knowing the principal and the vice president with their dynamism, that they will take you into this arena very soon, and I'm sure we'll be all glad to help, whether it's arbitrations or litigation, we will always be there to help you. And so the role of the impartial third party is to clarify the issues, and especially the underlying interests that lie in the heart of the dispute. The mediator may place as much emphasis, which does not happen in any other thing, on personal, practical, and business-related aspects of the conflict as well as on the legal aspects. It is a greater parameters. The mediator may help the parties explore not just objective dimensions, which all the other, even litigation is about, we always saying be objective about things, but the subjective dimensions of the conflict, such as beliefs and assumptions, emotions, the need to assign blame, and the desire for self-justification, which normally would be considered relevant in an arbitration. Those would not be considered relevant in an arbitration. If you sat down and started talking before any of us in our capacity as an arbitrator and said, he was dishonest, and go way out, we'd say, get back to the arbitration clause. This is determined by the four corners of the contract that you made, and it is less formal than the courts, but there is a thread of formality that runs through it. All of the information discussed in mediation is confidential, as is arbitration, but the interesting part here is the moderator cannot be drawn into litigation as a result of information uncovered in mediation. So the process of mediation involves few steps. It's generally called a 6-step thing, and it involves the preparation, and there's a lot of preparation, and this is something I think also who are involved in the inception of this process, we need to work on. The documents which give you that they are mutually in agreement, that they want to settle, not by way of any other thing, but by mediation. Now that document is essential because it gives you the leave and license to move into inquisitorial procedure between the parties. You facilitate that. So you go far beyond this, let's draft issues, let's stick to what is strictly relevant. Is it admissible evidence? All that is thrown out of the window. It is a humane approach. It is an approach which can embrace many emotions. And I, as a judge, sitting for many, many years, have often found that Justice Sarath Silva, I don't know whether you know this, Dr. Kanagisuran, Justice Sarath Silva would always say, if you don't settle this matter, especially in divorce cases and matters like that, I'm going to send you to Justice Tilakavardhana's court. It was a threat, and I would sort of wonder why he's doing this. But I always found it, I remember long ago, one case that came out was a famous two-tall company. And it was, so I just couldn't, it was such a brilliant company. And I could see the buildings were closed down. They had taken orders against each other. It was a family of brothers, and they had all fallen out. And the first question I asked him, did you build this business? No, our father did. And yes, he was poor, he struggled, and he put the business up. And I reminded them about it. And I said, what do you think? He was dead, long dead by then. What do you think he's thinking in his grave right now? To see his beloved children fighting with each other. And that case, very soon, and it started, and then I said, what is the problem? And I spoke to the first party. And mind you, this is at the stage of the appellate stage. And one brother said, I am the elder brother. And that was the bottom of the start of the problem. He felt disrespected. Before long, the matter was settled. And the company started again. And I think those are the happy moments that you facilitate. So whilst mediation we give terms, we have a special sort of a module for mediation, it happens all the time. It takes away conflict. And this is a comfortable area where a third party doesn't get involved, but hopefully common sense, emotions are aired, and it heals wounds. And then they start talking, because I think in today's context, if there was a problem, in Pakistan, who reached this position long before we did, if you want to curse a man, you would say, I hope you have a litigation in courts. That was a curse, because you lived with it for years and years. So the 6-step process is preparation, opening, communication, that is information and agenda that you get out, exploring interests. And to do this, we break out into caucuses, which is one party sits with this mediator and airs all the grievances. And that conversation cannot be released to the other side unless the permission is given for it. Then you go into exploring interests, developing options, and then you start drafting the agreement. Now there are three, can I say just a few things more? There are three main styles of mediation. Because this is, if you're taking notes, or if you want to think about it, there are three main styles: evaluative, facilitative, and transformative. Evaluative is more, to get to the point, and it's very efficient, and to find a solution. And you're told, well, we can finish in 1 day, 2 days. I think we don't have much experience right now in mediation in Sri Lanka, but Singapore seems to have mediations that settle in 1 day and 2 days. It's difficult because we are very different to Singapore. Because in Singapore, very rarely are arbitrations and awards and mediation settlements set aside by a court. And it is fast-tracked right up to the Supreme Court, which is, I think, what we really miss in our country. I know many cases where they're actually sitting and listening to evidence all over again in an arbitration. And that is not there. It is just totally an anathema in arbitrations. But this is a problem, so we have a lot of improvements to go ahead on. It gets stuck at various points. So we need a very quick fast tracking for it to bring back the credibility of our system. So it's good for short, generally, where the problems have been concrete, and if you fail, you're going to end up in court. Transformative mediation is, like I told you about the Tutol case, with a transformative approach, which makes time and space for all sides to really sit in here and understand each other. Transformative mediators create more space for emotions and expressed through a process and to help support emotional healing. And actually we have discussed that when we were having our classes. The dispute heals, and it is good for ongoing support, for relationships to continue, and therefore the contracts to continue. It doesn't terminate those contours. And I'm ending up with this. The facilitative mediation is between evaluation and transformative mediation, as it facilitates, and it's called facilitative mediation. Facilitative mediations mediators are based on the parties' dynamic needs. They may use techniques, both evaluative and transformative approaches. Using a facilitative style, a mediator asks questions, normalizes perspectives, and validates both parties' point of view. I'm just giving you in a nutshell so that you see the variety. I mean, it's like a kaleidoscope. Different things are happening. What is the end result? Harmony, peace, and a resolving of disputes. Thank you.
Yes, thank you very much, Madam, for that thorough and comprehensive discussion on mediation and the process itself. If I can bring Ms. Vare into the discussion at this stage, Madam, can we look at the institutional perspective, because Dr. Gunavansa also spoke about this specifically, that infrastructure is one aspect that really has to be in place, I suppose, for either of these ADR mechanisms for it to work. From an institutional perspective, where do your thoughts lie, because you have experience in both spheres, so to speak, if you can give your perspective in that regard.
Thank you, Rehan, and thank you for inviting me. The ICLP and the IADRC have been always very pleased to support the Sri Lanka Law College in the Victor's Moot, and I think this year too we are happy to support you, and we think you all have done really well. So on the question that Rehana asked, if I can just add to what Justice Tilakawardena said, she gave you a good overview of what mediation is, so I don't want to go back there, but mediation is not new to Sri Lanka. There is the Mediation Boards Act of 1988, and thereafter the Special Categories Act, Special Categories of Mediation, that was 2003. But that deals with community mediation, basically low disputes of a lower value. So it should not be confused with the mediation that we are discussing today, which is commercial mediation, which is the buzzword around the world today in ADR. So the commercial mediation has become so popular that even the United Nations decided to have a convention on enforcement of settlement agreements by way of mediation. So that's how the institution got involved, because we realized that we must bring in commercial mediation into Sri Lanka, because as you know, we have been involved in arbitration since 1992. I think Dr. Kanageshwaran started the ICLP with Mr. Kadrugamo, and they brought in a team of experts to draft the arbitration law in 1995. And going back to both, I mean, Sri Lanka being an arbitration hub has been a sort of goal of ours since 1995. Dr. Kanageshwaran went around the region promoting Sri Lanka. We had so many centers coming in as early as 1996, Malaysia, India, so I don't know whether you recall, where we promoted Sri Lanka as a regional venue for arbitration. And they were so amazed with the country, the facilities, all of that at the time. But unfortunately, our practitioners, and I would blame the business community also to an extent, because they did appoint persons who practice arbitration in this way, they actually took it away from us. So now we are trying to bring it back. And I think now it is a wider scope, because a hub for ADR, I think, should be our mission, not just arbitration. So from an institutional perspective, what we have done is introduced rules for mediation. So if you go on the IADRC website, you will see the rules that we have drafted based on international standards. So what we have realized is that to be a mediator and to promote commercial mediation and not make the same mistakes that we made with relation to arbitration, where we just let the practitioners take it away from us, I think the main thing is training. So even arbitration, we have started training younger lawyers into modern methods of arbitration so that the practice is different, where we are encouraging them to sit from morning till evening. We are encouraging commercial parties to appoint these arbitrators, particularly for their lower value disputes, so that then these young people will get the experience and become well-trained, disciplined arbitrators. So for mediation, also we're starting with that. We're starting with training. We have trained a mix of senior and junior lawyers and also commercial people in mediation. And at the start, you think, okay, mediation is something perhaps a person with knowledge comes in and, as Justice Tilakawardena said, help the parties come up with a settlement. But it's not just that. A mediator has to have technical skills, and from what we have learned, lawyers have the worst skills of being a mediator. So you have to really unlearn your lawyering skills if you want to be a mediator, because you have to learn to listen to parties. You can't make your own opinion. You have to have parties actually come up with, question them in a way that they come up with what really is the issue. And that's how the parties, and you encourage parties to come up with their own settlement. So that is lawyer being a mediator, but the lawyer can support the mediation process. So you would see in most rules, lawyers are not allowed to actually represent their clients, where they would argue, like in a case of an arbitration or in litigation, the lawyer would present the case to the arbitrators or the judge. But in mediation, the lawyers play a very supportive role. So they have to assist their client to bring out all the issues and actually learn as to what is the real issue that's underlying the problem to resolve the dispute. So the lawyer has a complete shift, and that's something we really also need to train our lawyers in. So the institute is trying to bring in what you call a lawyer mediation advocacy program, where we are planning to train many lawyers and get international support to have advocacy programs in mediation. And when you compare the two, I don't think you can say mediation is better than arbitration or arbitration is better than mediation. I think we shouldn't go there. The world is going to a trend of arb med arb, which is you have an arbitration clause in your contract, which gives the parties the sort of confidence that if there is a dispute, they can go into arbitration and have an award, which they can enforce. But there is also contracts now include what you call either arb med arb clause, where they can decide to go to mediation if they decide, because when you go into arbitration, your issues are kind of already set out. You have decided what your claims are going to be. So that's a good stage to go into mediation, because then you know what the issues are, and then you have the ability to go back to arbitration if the mediation is not, if you don't come to a settlement through mediation. And what we've learned, as Justice Tilakawardena said, Singapore does it in 1 or 2 days, and there was a leading counsel who came and sort of spoke to us on advocacy. So I asked him what type of disputes. Is it only small disputes? Is it big disputes? And how do you convince your clients to go into mediation? And he said they do very big disputes, construction disputes of bridges and roads. Lots of them are also mediated settlements. So you can have a combination of both. As I said, you can't say one is better than the other. Sometimes mediation suits a particular type of dispute, but in certain cases, you would require arbitration because of the amount of evidence and the fact that you need an enforceable award. So then comes the question of, is a settlement agreement enforceable? So currently it's enforceable as a contract, but with the settlement agreement, it would be a contract, and you can have an arbitration or another mediation clause in that contract if the parties don't actually honor the settlement. But what we've heard is it's very, very rare. Again, I think Justice Tilakawardena said that. Very rare that a party actually challenges it outside so far. So we don't know how it is going to be here. So for that, the IADRC has drafted 2 laws. One is to ratify the Singapore Convention on recognizing settlement agreements entered in the mediation process. Dr. Kanageshwaran has helped draft that law. Can be enforced in Sri Lanka. It's currently with the legal draftsman. And we are also introducing a civil and commercial mediation law, which sets out the principles of mediation, regulates quality of the mediators, the fact that we sort of ensure that confidentiality is maintained and that the settlement agreement can be made a decree of court, and ousting jurisdiction of the courts during the mediation process like the Arbitration Act. So those are the steps that we have taken to introduce commercial mediation into Sri Lanka, but it all depends on those who practice it. So I think we must try not to make the mistake we made with arbitration, where we let the practitioners kind of take it away from us, and bring in a very developed, trained set of mediators who would be able to assist in making Sri Lanka that hub for ADR in general.
Yes, thank you very much, Madam. Just keeping in mind the time limitations that we have, I'm sure the participants are also eager to find out what the results are. You, Madam, touched on some interesting points with regard to especially enforcement, and preempted actually my next question, because I was going to actually put the panelists on the spot slightly to ask them to try and choose a side, because that's the topic we have in our hands at the moment. If I were to push you to choose a side, I suppose Ms. Varia is standing on the fence when she says that, try to couple up the two options together. But if I were to push you to take a side, either arbitration or mediation, and if you can back that up with on a principle-based answer as to why exactly, current status quo as it may be, why you would choose at the current status quo either mediation or arbitration as a suitable option for a party who is facing a dispute. If we can maybe go to the remaining three panelists to get their thoughts on that.
Asking me?
Yes, sir. All three of you, sir.
Well, all these dispute resolution mechanisms, as they underline, is meant to resolve a dispute that people have. Now, we heard a lot on mediation. There's a fundamental difference between mediation and the other dispute resolution mechanisms. Broadly, mediation, from what I have seen, I am untrained, I have seen examples demonstrated about mediation, how it takes place. It appears to me to be fundamentally driven by two imperatives. One is the trust that should be generated by the mediator among the parties. The other is the question of empathy. The mediation, as I see it, is a process by which you have discussions with a particular party. They spoke of caucuses that been there divided into two groups, individually, to understand what is really the problem that which precipitated the dispute. So apart from the superficiality of disputes and saying I am the eldest son, I am so and so, so and so, there is a fundamental core which is at the bottom of it, which created the dispute. Understanding that requires empathy. You must understand, you are not intelligent, but empathy, you know what empathy is. Then you have to appreciate, understand and absorb what her problem is before you go and speak to her, what her problem is. So it's not an easy job, I think, from what I learned. As Shehara rightly said, you must unlearn all that you learned as a lawyer or an arbitrator when you are going to mediation. So that you must generate the trust so that then the mediator will go and speak to the other side and understand what is it that is driving them towards this dispute. So the minimum involvement of the lawyers is best suited for mediation. Of course, questions of rights arise, legal issues arise. In that, they may advise their clients, but it is the client who speaks to the mediator, if I am right. So that when they come to the selection, which of the dispute resolution processes will you advise? Suppose somebody comes to you and says, then you have three alternatives in front of you: litigation, arbitration, mediation. How will you decide to select them? So it may depend on the nature of the dispute. Not all disputes may be suited for mediation. Not all disputes might be suitable for arbitration. Mind you, arbitration and mediation are consensual processes. The underlying theme is that you agree for this process out of court, so that you will honor it. You are required to honor the dispute that is being settled either by mediation or. So it's only where you dishonor them that you go into the process of enforcement. So in selecting, you might find with experience, some cases simply do not admit of mediation or arbitration. They go to litigation for various reasons. There might be several compelling reasons today as to why they say arbitration takes longer than litigation, so I am told. That those apart, the fundamental issue involved in this adjudicated process, dispute resolution, is very different. So you must understand the motivation behind the creation of the dispute resolution mechanism to be able to decide whether a particular dispute that has been placed before you is suitable for one, this or the other. So that is, I mean, I don't want to take more time on that. So you need to be very careful in selecting and advising if somebody comes to you, and because, of course, as Shahara said, you can start with mediation, slide into, as we say, negotiate, mediate, arbitrate. For construction disputes, I can't see construction dispute ending in mediation. You can't. Some vitriolic fight between companies would take over cannot be the subject matter of mediation. So it depends. That's the short answer to your question.
Thank you, sir. Madam.
I'll go along with the mandate you gave us, and I'll sort of set out not only the advantages of mediation. Of course, as an arbitrator, I mean, I'm wearing a different hat today, right? So as an arbitrator, I would support a lot of what Dr. Kanageswaran is saying, and in fact, add to it. Because I think the problem is in the methodology. They delay it. There's no reason to delay at all. There's absolutely no reason. The delay is partly because you bring in counsel who have a lot of work, and they cannot accommodate you on the dates. So I've learned that the trick is, well, okay, what is the date? What is to do it in trunks, tranches where you have 1 week, then few days, then another 1 week. There the problem is the proceedings. So we have been doing Opus 2 conferences with Mr. Rodrigo and those are fantastic. That is the technology, and it is just this marvelous, where we had thousands of documents, and we actually finished that within few months, 3 months or 2 months for the trial, and then it took another, for written submissions, and we finished it within that time. So it is, the technology is there. I would recommend Opus 2 to anybody, because it actually saved. It is very expensive, but it actually saved things. And in that sense, I think all of us as arbitrators, mediators, everybody has to start learning the new technology. It is, and we picked it up fairly fast, right, Mr. Rodrigo? There was no problem at all. Yeah. So I just tell you a few things of mediation, but being a judge, I'm also going to tell you, with your permission, right, a few of the disadvantages. So advantages, it is economically, is generally far less expensive to do mediation. And in fact, they had set a very, very minimal fee. I don't know whether anybody would come and do it for that fee, but if you can get it done, and by competent mediators, that's very good. It is a rapid settlement because you quickly come to the concrete part of it and you settle it. There's mental satisfaction. Parties don't go away aggrieved and bitter with each other. And that's very important, because now we are all talking about emotive intelligence. As artificial intelligence developed, we're talking of emotive intelligence, which includes empathy. And that is coming into the judicial system now. High rate of compliance, they agree with it, they go and comply with it. Comprehensive and customized agreements, you can always fall back on a template that is already pre-prepared to write down the settlement, greater degree of control and predictability of the outcome. No longer do we have the days where the same facts based on the same law comes out with a uniform decision. And that is worrying, because they'll say, look at it's like the old, Tale of Two Cities. She said, show me the judge and I'll show you the law. That should not happen. And I think we are concerned, very concerned about it. All the President's Council, the seniors in the practice, we are concerned about that. That shouldn't happen. And as a consultant to the Judges Institute, I take a lot of trouble in talking to the ethics of Bangalore principles and all these things, right? So that shouldn't happen. But here, there's a predictability of the outcome. And that is a great satisfaction. You know you're going to sit with the person, you know you're getting out of that room and the matter is settled. Then there's personal empowerment. There's a feeling, but I also contributed. Parties feel great about it. Preservation of an ongoing relationship. Workable and implementable decisions. It's practical. It's not based in res ipsa locuta, uberrima fides. All these are left out in this 8 in simple words, simple things they understand. Agreements that are better than simple compromises or when you agree, you don't have the win-lose situation. Decisions that uphold over time. But there is also the negative part of it, and I must say it as a judge, give you that balanced way and to work on those things. Results are not guaranteed. Withholding of information takes place because all people who sit around that table are not honest and, they don't have the correct, they don't disclose everything. There's no discovery process. I find that a huge deficit in it, where you can't discover information. There's no discovery process, there's no formal process, and no consideration of the merits of the case. So we always say it is res judicata, where there is an adjudication on the merits of the case. What happens if there's a mediation? Can you say, well, there was an adjudication on the merits of the case? Those are matters of law, which I'm sure will develop with interesting judges and interesting lawyers and their arguments, especially the senior lawyers. And for instance, it is very useful in workplace disputes, in divorce and family law. I know many, many young people. They seem to get into marriages very fast, and they get out of it also very fast. And the sad part is their lives are put on hold because it takes years for a fault-based system to ultimately give you that decree absolute, because it goes to different courts. And it just destroys lives. And I'm totally for that. Is really, I think mediation would be the answer, but you have to open your institute for mediation in personal matters, because it's civil law, and if you can say civil mediations, you will not know where to stop because you'll be inundated with cases because it's very private. People, even for an ex parte case, you don't have to go and stand in courts and give evidence. So business partnerships, community disputes, and there are 4 cases, and if you like to talk about it, there is mostly on Oregon, in Canada, about the lakes dispute was one of the disputes that were settled. School disputes can be settled. Construction disputes strangely get settled because it's really about contours of a particular, say, construction or something. It appears can be settled through mediation. I may be corrected. Elders' care issues and permits in the naval dockyards. The Navy never took part in anything until they said, let's sit down at a table and sort it out, and it was sorted. So I can give you some of the examples about the apple timber sale in Oregon, mediation between the Burkina Faso and Mali dispute, in the large disputes between countries. Mediation is what worked, not arbitration. So, maybe even in the settlement between our own ethnic problems, probably we need good mediation to settle it. But it's definitely all these are, as you said, to have a peaceful and harmonious situation, especially in multi-ethnic, multi-religious and multiracial countries like ours. Thank you.
Thank you, Madam. Dr. Gunawan, sir, do you have a perspective in this regard?
So very briefly, let me say this. I don't think these are 2 competing processes. I look at them as complementary processes. Because there are certain disputes, like Dr. Kanageshwaran said very rightly, mediation may not be suitable. But even those disputes where mediation is suitable, by two parties agreeing to have a mediation clause and participating in mediation does not mean that always there will be a mediated agreement. So if there is no mediated agreement, there should be somewhere else for them to go. So the choice is litigation or arbitration. So the current trend, therefore, is to have tiered dispute resolution clauses where you have arbitration as the final mechanism. That is because arbitration is, the popular perception is that arbitration is cheaper, more efficient, effective, and so on. And also when it comes to international contract, it could be enforced due to the New York Convention. And you guys can read up about the New York Convention. I'm not going to explain that to you now due to interest of time. So with regard to mediation, in mediation, a mediator will facilitate the two parties to identify issues and then thereafter also try to facilitate the parties to come to an agreement. Whereas in arbitration, arbitrator will consider the facts, evidence and the law and make an award. So that is the key difference between the two. There are a whole heap of others, but if you know that, then you can use your common sense and see, what the difference is. So a final remark again, as young lawyers, if you're looking at mediation and arbitration, don't ever think of them as competing processes. It's always good to think of them as complementary. Try to do mediation first. If you can solve the dispute with mediation, that's the best. Failing which, you have to have provision to go for arbitration.
Thank you very much, sir. Ms. Farah, do you have anything to add to your answer?
Not really, just to add to what Asanga said. So the Singapore Convention is the equivalent of the New York Convention in mediation. So where the New York Convention allows you to enforce an arbitration award, the Singapore Convention allows you to enforce a settlement agreement entered into by way of mediation. So like you said, you should read up them, and they definitely are both complementary processes. The tradition is mediation and then arbitration, but if you read online again, it's now becoming ARB-MED-ARB, which is arbitration. You go into mediation, you have the choice to go back to arbitration.
Yes, thank you very much. I know we are 5 minutes over the mark of the time limit, but are there any questions from the audience? Yes, sir.
Rodrigo, can you catch?
If I can just ask this, I don't want to be a killjoy here, but I don't have any experience whatever with mediation, but what I've been listening to up to now, we've talked about empathy, emotional intelligence, healing hurt, harmony, all of these things. I haven't heard the word law from any of the learned panelists. We have legal luminaries in front of me, and my question then is that, and I understand this to be correct, that law plays, if at all, a very secondary role in mediation. So you put aside legal considerations, at least to a large extent, when you embark on a mediation process. So here we have the young ladies and gentlemen from Law College, the principal and the vice principal also here. My question is, what is the role for lawyers in mediation, if any? And also, perhaps, I would venture so far as to say that if they get too involved, because lawyers certainly don't wear these hats of being empathetic and so on, nor is that part of our ethos, if you like. And certainly if law is also going to be secondary or play almost no role, then what is the role of lawyers? Why are we here listening to these matters on mediation in this forum? As I said, I don't want to be a killjoy, I just want to pose this question. Yeah.
I think you stepped out for a smoke when I was discussing the lawyer's role. So basically, the lawyers have two roles, if I may start, and I think the other panelists will be happy to answer you. So yes, you're right. The legal rights are left aside in mediation, and that's supposedly the beauty of it, where you encourage the parties to look at what's really upsetting them, and they are allowed to always go back. So you're taught as a mediator to tell the parties right at the outset, until you come to an agreement, you're not settling for anything. You can always go to litigation or to arbitration. And a mediator is also always trained to ask the question, okay, you're having this dispute. Have you thought about how much you're going to spend if you go into court, or how long you're going to take if you go to arbitration or litigation? So the lawyer's role is twofold. Lawyers can also be good mediators if they train themselves to listen and get the parties, because you have that, you are able to analyze the actual dispute by talking to the parties and finding out what the real issue is and leading them into a settlement. And lawyers can also play a supportive role through advocacy, where they sit with their client and help their client to understand what the problem is and come to a settlement. The only difference in mediation is the lawyer doesn't represent, as in they don't argue or present facts on behalf of the client. Of course, they can speak to the mediator, but that's the difference in the role. But I think lawyers still can play a very important role in the success of mediation as well in Sri Lanka. And if it's so successful around the world, I'm sure there are things that we can also learn from that and make mediation as successful as arbitration, or better than arbitration. Actually.
Yeah, if I can compliment what Shara says, being nothing can take place in a vacuum. There has to be a legal framework reference. Even for mediation, we have drafted the Mediation Act. When that's put out, I mean, it's there with the Ministry of Justice, I don't know how far they. So that will set out the parameters within which commercial mediation, we are talking about commercial mediation. Commercial mediation take parameters. How will you agree? What are the matters on which you can agree? Lawyers cannot be banished away. We will always be required. Only our roles will change. Even in a mediation, it has to be done in the framework background of a law. So therefore, any settlement must be tested as against the law. So it cannot be which is against the law. So the lawyers have a role. Only the role is different. That's what I emphasize. Even a lawyer can take place. You mentally adapt yourself to create in you an awareness of mediator role is slightly different from a lawyer's role, in the sense that people must be able to trust. If there's a trust deficit in the mediator, it will never work. But once it is there, it is done within a legal framework. Now about the question of enforcement. Of course, we are a litigious nation. We agree to, but we always dispute it because you want to buy time, you go to court, you go to. So therefore, there is a compulsory element of enforcement being provided for, as Shara said, the Singapore Convention. It's our New York Convention vis-a-vis arbitration. So the lawyers are required. Only the role they will play will be different. And even during our mediation, but I understand, the parties can take advice from the lawyers on legal issues. Sometimes they are present, sometimes they are not present. So the advantage of mediation is the parties can pour their heart out to the mediator. There is no confrontation, I mean, in theory. We have seen modules of how it's done in Singapore, and they came and so internationally, mediation is a fashionable thing now. Most of the European countries, Canada, especially about 80% of the disputes are done by mediation. So we need to, as Asanga said, our culture must change, how we look at it. That's why nothing works in this country, because we are still stuck to the old habits.
If I may add to that, statistics show that lawyers are heavily involved in mediation. And there was a study done in countries like Singapore, Philippines, and Malaysia. And more than 75% of the qualified or active mediators were lawyers. And in addition to that, all the legal principles pertaining to voiding a contract, validity of a contract, will agree to a mediated agreement. So as a result of that, even when mediation takes place in the absence of a lawyer, to finally settle the agreement, they keep coming to lawyers in order to make sure that that contract has a binding effect.
For the benefit of the students and also lawyers, the institute is bringing in advocacy programs, as I said, mediation advocacy, training on mediation advocacy. And we're trying to get international support for that, so we can learn how the role of lawyers and how we can best play that role in mediation.
Yes, thank you, Justice Lagwat. Anything to add to that discussion?
I think most of what needs to be said has been said. I don't think you can take away lawyers from anything, because I think they always have a role if they have a trained mind and they know that there are different aspects of law, especially now the environmental law is developing so much. I don't think you can, I don't want to say a mean joke about it, I'll be quiet, but you can ask me about it when I get off. I think that lawyers will always be there, but maybe in a different capacity, because this strictly stipulates no lawyers can take part on behalf of the parties. I think it's on the view that when lawyers come in, it just gets dragged on. It gets much more acrimonious than, and there's a confrontation. It's not a peaceful resolution that they are the cause of destroying the peace and keeping the peace destroyed for as long as possible. So I just, I just want to, I mean, not all lawyers, of course. Obviously, we have great respect for many of the lawyers who are here today with us. I mean, I have held them as role models when I'm teaching judges. I said, look, listen to and they teach you law. I have learned many good, how to expand the law, through submissions of counsel. And I must say that role between, from one side of the bench to the other makes both grow. But of course we need ethics. We need to understand what is impartiality. Because I don't think you can be a good mediator or a good arbitrator or even a good judge if you do not understand the fundamental thing about any kind of dispute resolution. And that is integrity. That is also, I would refer you to the Bangalore principles which talk of independence, equality. What is equality? All people are equal. They have the same rights. They have equal standing before the court. We pompously say it, but we know that when they come before our courts, the rich lawyer obviously is not equal, the litigant is not equal to the poor man who comes from a Haramanis, who comes from a village, who can only afford a lawyer who does not even speak in English. And I have sat on the bench in the Supreme Court, hearing somebody stumble along. But at the end of the day, some of the greatest public interest litigation decisions, like the mechanized mining, where part of our country was growing into deserts in certain areas, where the Supreme Court intervened and we did public interest litigation with a lot of activism, came from such lawyers who got up, stood up bravely and spoke. Maybe not in the perfect English, but then English is our second language, so it does not matter. It just needs you to have a cause, to feel passionate about it, and to study the law. Whatever language, you study that law and you give it to the judge. And if you have an impartial hearing, you have all the Bangalore principles. We talk of propriety, where judges would give you a decision that is founded on the facts in the law, and that there is a uniformity in the law. So they know this question of expectation. One of the selling points of mediation is that you never know when you go before a court what is going to be the outcome. And that is one of the main selling points. That is right. It shouldn't be happening like that. So it's very much a matter of ethics, principles. And I think at the end of the day, every one of us who sit in positions of decision making of any kind, of facilitating of any kind, have to understand what is equality. And equality is where all people are equal at the end of the day. Difference must not disadvantage people, whatever religion, ethnicity, or poverty line they're at. Thank you.
Thank you very much, Madam. At the outset, I was given 45 minutes to an hour, so we have just gone past the hour mark. I'll call it quits at this stage. Just to offer my thanks to the eminent panelists for the very interesting discourse that took place. Thank you very much to the organizers for having us, for the invitation. I suppose the answer to the question of is mediation a better alternative? I suppose the answer is use them both. It's part of the same spectrum. Use litigation also as an option. See what your client's need is and offer the best solution that fits. Also, as a word of advice, I suppose that's the principal point that came from that last question. Thank you very much to Mr. Rodrigo for that. That as budding lawyers, you are entering a profession that is saturated. A lot of senior counsel might not be privy to ADR as a suitable option. If you use ADR as a suitable option, give it to your clients, the clients you will be meeting soon, I think you will be able to leapfrog quite a few of some of the senior counsel as well. So use it as an option. It's arbitration is now being offered as an optional subject. Take it. Hopefully, it will be part of the curriculum also in the years to come. Thank you very much, and good luck for the results.
Yes, thank you very much to our esteemed panelists and our moderator for that very insightful and timely panel discussion. And to extend our heartfelt gratitude towards these individuals who cleared out their busy schedules to be present here with us and enlighten us this evening, I would now like to invite the chairperson of the Victors Moot 2023 Committee, Sayuni Fernando, to present them with tokens of appreciation. To Justice Shirani Tilakawardena, retired Judge of the Supreme Court of Sri Lanka. To Dr. Kanaganayagam Kanagiswaran, President's Counsel. To Dr. Asanga Gunawansa. And to Mrs. Shihara Varia, Attorney at Law. And of course, to our skillful moderator, Mr. Rehan Almeida, Attorney at Law. Thank you very much to our esteemed panelists and our moderator. Next off on the agenda, ladies and gentlemen, is a review session, reviewing and focusing on all aspects of analysis, research, and advocacy displayed in the process of Victors Moot 2023. And I would now like to introduce to you the esteemed individual who will be conducting this review. Mr. Avindra Rodrigo, President's Counsel, is also a barrister at law of the Gray's Inn and is head of the litigation division of FJ&G de Serum and has over 20 years of experience advising and representing both local and international clients in commercial and corporate dispute resolution, including arbitrations held under the rules of the SIAC, the LCIA, and the ICC. Mr. Rodrigo also authored the chapter on Sri Lanka in the Chamber's Global Practice Guide, Litigation 2019, edited by Gary Bourne and John Macmillan. Mr. Rodrigo also co-authored the chapter on Sri Lanka in the Asia Arbitration Handbook, edited by Michael J. Moser and John Chung, first published in 2011 by the Oxford University Press. I would now like to hand over the proceedings to Mr. Avindra Rodrigo, President's Counsel.
I'm to talk about, I think I'm to talk about a little bit of a review or analysis and advice on mooting and points that we as a mock tribunal today with Justice Shirani Tilakawardena and Dr. Gunawansa and myself, we wanted to share with all those who are present here, who participated, anyone else who's interested in mooting, and all those who are joining us online. Um, the first part of this is going to be the first point I'd like to make here is about demeanor. I think as law students, most of the participants were law students, they may not know or realize that there is a particular demeanor, carriage, way of presenting yourself. I know arbitrators are not the same as appearing in the higher courts, for instance, but it is essential that you treat the arbitrators with a certain level of deference, a certain level of respect. You should always allow the arbitrators to speak, listen to what they say, give due recognition to their thoughts and their ideas when you respond. So that is one, and part of that is even if you are doing this virtually, it is important that you present yourself well on the camera. And one of the things that we noticed was that some of the participants were not squarely in front of the camera. We could not see them fairly and squarely. All of these things are important because we do have virtual hearings now, so these are things that you will have to practice at one point. If any of you who did the moots today do end up practicing as in arbitrations. The other is that you need to realize also that arbitrators are human, and you need to address your submissions, your points to the arbitrators. It should not be the case that you read off a prepared script. That is something that is not engaging to an arbitrator, as it wouldn't be to a judge or any kind of officer who's holding an inquiry in a forum. So don't read off a script. Try to address the arbitrators as people who are responding to what you're saying. Also be mindful of how the arbitrators are receiving your submissions. They may be negative, they may be positive. Also give them time to absorb what you say, because arbitrators tend to be old or older, shall I say. There have been arbitrations in which at least 2 or 3 of the arbitrators passed away during the course of a proceeding. So be mindful of that and don't rush your submissions. Just rattling off what you're going to say is not going to carry much weight with them. So that is important. The other last point is about questions. So it is really at the point at which arbitrators ask you questions. I'm talking about moots, and I'm assuming that you want to reach the standards that are reached in actual arbitrations in your moots. The questions indicate the way the tribunal is thinking, so they're important, and you should welcome them even though they may not be at the right time, you may not be ready for it, and all of that. So welcome the questions, and when it is the role of a set of judges like we were, what you say and how you respond to a question can give you a lot more points than what you have come by way of a prepared speech and say. Do you understand what I'm saying? So welcome the questions. Try to see what the arbitrators are getting at. Don't avoid the issue unless you have to, if you have a very bad case. One side today, I think, had a harder case than the other side. But try to address the questions. Try to focus on what the arbitrators are asking, because that is probably where the bulk of your marks are going to be, and it will make the difference between your winning or losing a competition. Yes, but having said all of this, we have to say the standards were very high today, and it was not easy for us to come to a decision. The decision is going to be announced soon, I believe. And who knows, the contestants we had in front of us or any of the others who participated today, if I or the other judges live that long, maybe you guys will one day appear before us. So thank you and good evening.
Thank you very much to Mr. Avindra Rodrigo, President's Counsel, for that very in-depth review of the performance. And I would now like to call upon the Chairperson of the Victors Moot 2023 Committee, Sayoni Fernando, to present a token of appreciation to President's Counsel Avindra Rodrigo. And with that, ladies and gentlemen, we have come to undoubtedly the most awaited segment of this ceremony, where we celebrate the skills of legal advocacy. Written advocacy, which is tested in the way of memoranda for claimant and respondent, as well as oral advocacy, which is of the utmost importance, that is, to deliver an argument clearly and succinctly, as well as the depths of research, the quality of your authorities, and the analysis of complex legal issues, which were all standardized and examined throughout the course of this year's Victors Moot, as it always has been done. And now the next segment will honor all the hard work put in by all the participants. Firstly, we will felicitate the participants of this competition. Firstly, those who are here with us virtually, our international teams. The University of Petroleum and Energy Studies, comprising of Mohd Said Hashim, Pranoya Chatterjee, Jahanvi Agarwal, and Vanchika Bairagi. A round of applause for the team. Next, the Law College Dehradun faculty of Uttaranchal University, comprising of Rohit Verma, Jatin Rana, and Sumit Kumar. The Dr. Ram Manohar Lohia National Law University, Lucknow, comprising of Aditi Joshi, Bhavna Botra, Akarsh Anand, and Mudrika Jha. The West Bengal National University of Judicial Sciences, Kolkata, comprising of Soham Das, Abim M. Adrit, Tanish Jain, and Ryan Lihang Subba. The British School of Law, comprising of Nashra Chowdhury, Suhan Sarkar, Rashid Alam Sifat, and Mahjabin Mahbub. The Rajiv Gandhi National University of Law, Punjab, comprising of Tanishka Kapoor, Hiya Goyal, Ganjan Yade, and Ananya Sahu. And now, to present the participation awards to the teams who are present here with us this evening, I'd like to call to the stage the Principal of Sri Lanka Law College, Dr. Atula Patinayaka. We'd like the teams to walk on stage and collect their certificates and awards. The Open University of Sri Lanka team, comprising of Lahiru Pereira, Fatima Shazna, and Shangavi Sarvana. The NSBM Green University team, comprising of Jenny Anisha Anthony, DMU KK Disanayaka, Rahal Karunasena, and KMAP Kulathilaka. SBM Green University. And next off, the team from Epit Law School, Colombo, comprising of Netra Sirivardhana, Nusha Amin, Sai Sruta Thayaparan, and Shanil Boteju. Next off, the team from the Faculty of Law, University of Colombo, comprising of Malkini Fernando, Nuha Hamim, S.A. Atukorala, and Lakshita Sampath Bandara. We also had the team from General Sir John Kutalavala Defence University, comprising of Devmini Bandara, Ranidhi Lokugamheva, Sohan Vipulananda, and Nimsara Rupasinghe. We will also mention the team who from Apit Sri Lanka Kandy campus, comprising of Anuttara Disanayaka, Shakira Tubasiddiq, Benuri Navagamur, and Hayden Premachandra, who cannot be with us here in Colombo this evening. Thank you very much, sir. Ladies and gentlemen, a big round of applause to all our participants for taking that very brave step in learning something new and adding to their list of experiences. The skills of written advocacy are measured through legal memoranda. And as per tradition, the best two memoranda for both claimant and respondent will be felicitated now. So first of all, we have the runners-up for best memoranda for claimant. Give it up for the Maharashtra National Law University, Mumbai, comprising of Lavanya Segal, Mokshi Raval, and Chitrakshi Kapgate, and Damodaram Sanjivaya National Law University, comprising of Palla Harini Devi, Gugliam Charisma, Ritika Verma, and Jakir Hussain. A round of applause, ladies and gentlemen. Next off, moving on to the award for the runner-up for the best memoranda for respondent. And to deliver this award, I'd like to call on stage the Director of Finance and Administration at the Asia Foundation, Mr. Nalim Jaivikrama. Ladies and gentlemen, the runner-up for Best Memoranda for Respondent goes to the Royal Institute of Colombo, with the team comprising of Imad Imran, Romasha Senuri Silva, Udam Vikramasinghe and Asala Rajapaksha. And now we will move on to our winning memoranda. One of the challenges of drafting memoranda for moot court competition is switching the sides. First you draft a memoranda for claimant, and then you end up having to research against your own arguments that you drafted the first time. So, without further ado, it's time for the award for the best memoranda for claimant. The team from Symbiosis Law School, Pune, comprising of Saksham Kumar, Shubhangi Kumari Mishra, Sharat Pillai and Adiba Akhlaq. And now, for the best memorandum for respondent. This, once again, is a shared award. Give it up for the teams from Damodaram Sanjivaya National Law University, comprising of Palla Harini Devi, Gugliam Charisma, Ritika Verma and Jakir Hussain, and the team from CFPS Law School, can we have them on stage, comprising of Vinodini Rajapupati, Muhammad Lukman Riham, Shavini Lakshani Surya Arachi and Sivagami Divya Tiruvadinathan. Congratulations so far to all the teams. Thank you, Mr. Jayavikrama. And now the skill of oral advocacy is measured through the ability to deliver complex legal arguments succinctly, clearly and to the point, as well as entertaining questions from a curious tribunal. So the first award for one of the best oralists that we have had is a very special award that is unique to this year's edition, where the tribunal specifically requested that this award be presented to a very good oralist of the final round. So ladies and gentlemen, the best oralist of the final round award goes to James Ethan Hau Song Eng of the Singapore Management University Yong Pang Hau School of Law. Congratulations to James. And now the runners-up award for the best oralist. This, once again, is a shared award, and it is shared by Lim Shi Han of the Singapore Management University Yong Pang Hau School of Law and Donna Gadiel of the School of Excellence in Law, the Tamil Nadu Dr. Ambedkar Law University. And we will now present the award for a display of exceptional oral advocacy. The award for Best Oralist at the Victors Moot 2023. And this award goes to Shivani Gotra of the Institute of Law at the Nirma University. That thus concludes the awards for individual excellence. We will now move on to commemorate our semi-finalists. The semi-finalists at the Victors Moot 2023 are the School of Excellence in Law, the Tamil Nadu Dr. Ambedkar Law University, comprising of Nishasri S., Ashwad D., Donna Gadiel, and Rasha Hamid. A round of applause. Our next semi-finalists are from the Christ deemed to be University in Bengaluru, Karnataka, comprising of Shama K., Liza Christopher, Mary Kurian Idasari, and Karthika Raj Karna. A round of applause for our semi-finalists. Two more awards left, ladies and gentlemen, and these awards are a display of some fine oral advocacy, as well as, no doubt whether you were an award winner or not, the result of months of sleepless nights, enjoyment and hard work with a very different legal case every single time. It is now time to reveal the champions of the 2023 Herbert Victor Pereira Queen's Counsel Memorial International Commercial Arbitration Moot. Our champions this year are okay, we'll go with the runners-up first then. The runners-up this year are the Singapore Management University Yong Pang Hau School of Law comprising of Therese Lee Shi Huang, Lim Shi Han, James Ethan Hao Song En, and Saran Raj. A round of applause for our runners-up. Now do I need to announce the champions? Okay, we'll do it for good old formality's sake. Here it is, the result of a lot of hard work and the champions of the 2023 H.V. Pereira Queen's Counsel Memorial International Commercial Arbitration Moot. Ladies and gentlemen, give a thunderous round of applause to the Institute of Law, Nirma University, with a team comprising of Arnav Mehta, Sneh Singhania, Shreya Shukla, and Shivani Botra. Ladies and gentlemen, one massive round of applause for all our participants, award winners alike, for all their hard work, sleepless nights, and team calls that do tend to go on for quite a while. And also a big thank you to all their coaches for the immense effort that they have put in to present a good standard for the Victors Moot 2023. We have now reached the conclusion of the awards ceremony. Who are the next champions? Who are the next faces that will who will participate and win all the prizes and take home the glory? That remains to be seen next year in 2024. I would now like to call to the podium the chairperson of the Victors Moot Committee for 2023, Ms. Sayoni Fernando, to propose the vote of thanks.
Good evening, distinguished invitees, Principal of Sri Lanka Law College, Dr. Atula Patinaika, Deputy Principal of Sri Lanka Law College, Mr. Shehan Pereira, esteemed arbitrators, valued participants, and the organizers of the Victors Moot 2023. It brings me great pleasure as the chairperson of the Victors Moot 2023 to deliver the vote of thanks at the closing ceremony of the 6th edition of the H.V. Pereira QC Memorial International Moot Competition. While this may seem like just a competition that took place over 2 days to most, to us, the organizers, it has been several months of challenges, obstacles, ups, downs, and so many priceless memories. The Victors Moot is a pioneering international arbitration moot in Sri Lanka, and it fills me, as well as the organizing committee, with great pride to have been given the opportunity to continue the great work that has been carried forward over the last 5 years. This competition would not have been possible without the invaluable support rendered by the well-wishers and supporters of the Victors Moot that we treasure. And I am honored to have the opportunity to extend my gratitude to these individuals and institutions. First, I would like to thank the Principal of Sri Lanka Law College, Dr. Atula Patinaika, for his unwavering support of the Victors Moot and the Moot Society of Sri Lanka Law College as a whole. Next, I would like to thank the Deputy Principal of Sri Lanka Law College, Mr. Shehan Pereira, for your constant support in guiding in all things to do with the Victors Moot, from finding arbitrators to actively supporting this competition. I would also like to extend my immense gratitude to our special invitees, namely Dr. Kanaganayagam Kanageshwaran, President's Council, and the President of the Bar Association of Sri Lanka, Mr. Kaushali Navaratna, for honoring us with their presence and for making this closing ceremony truly special. I thank our esteemed panelists, Her Ladyship Justice Shirani Tilakavardhana, once again Dr. Kanaganayagam Kanageshwaran President's Council, Dr. Asanga Gunavansa, Ms. Shehara Varia, and our wonderful moderator, Mr. Rehan Almeida, for providing all in attendance here with a wealth of information and a renewed perspective on alternate dispute resolution. I would also like to thank our esteemed panel of arbitrators for the final round of the Victors Moot 2023. Once again, Her Ladyship Justice Shirani Tilakavardhana, Mr. Avindra Rodrigo, President's Council, Dr. Asanga Gunavansa for guiding us in our endeavors and in expanding the capacities of our treasured participants. I thank the panel of arbitrators for the semi-final rounds and the preliminary rounds for your invaluable support in making this competition a success. I extend my immense gratitude to our valued sponsors, without whom this competition and this closing ceremony would not have been possible. A special thank you to the Asia Foundation in Sri Lanka. I have no words to express how grateful the organizers are to the Asia Foundation for the immense support provided to us in all our endeavors. I extend my gratitude to our sponsors, ICLP, Tokyo Cement, and Mycola for your invaluable contributions in making the Victors Moot 2023 an immense success. I would like to acknowledge and appreciate the International ADR Center for providing us with the ideal venue in helping us achieve our vision for the Victors Moot this year. A special thank you to Ms. Damitri Valikala from the ADR Center for your constant support and in always being so pleasant and cheerful to work with. I thank our donors who wish to remain unnamed, but who occupy a treasured space in our hearts. I take this moment to extend my sincerest gratitude to our valued participants. You give this competition so much color, and without you, the true purpose of the Victors Moot would not have been achieved. And for this, we're grateful. I extend my gratitude to the Moot Problem Drafting Committee, whom we cannot name, but who we will always be immensely grateful to with providing support in terms of drafting the Moot problem and in answering all clarifications from the participants as well as from a sometimes confused organizing committee. I thank the Moot Society alumni who are many in number and constant in support. I thank those who have joined us here today, Nimanga, Daupati, and Harita. I extend a warm thank you to our media designer Madhushan for always delivering above expectations and for always putting up with our sometimes well thought out, most of the time last minute requests. To the Executive Committee of the Moot Society of Sri Lanka Law College, our seniors, I want to express my heartfelt appreciation for your unwavering support. We're truly grateful. Finally, I'd like to thank the Organizing Committee of the Victors Moot 2023 for their hard work and continued commitment. Without you, none of this would be possible. Thank you, each and every one of you, for supporting the Victors Moot and in making this edition a resounding success. We eagerly anticipate your continued support in future editions. Thank you.
Yes, thank you very much, Sayani, and a huge kudos to the organizing committee of the Victors Moot 2023. And with that, this year's edition of Herbert Victor Pereira's Memorial Moot, the H.V. Pereira Queen's Counsel International Commercial Arbitration Moot, comes to a close. However, it has opened up new friendships, knowledge, and memories, and this legacy will no doubt continue. Distinguished invitees, ladies and gentlemen, until Victors 2024, take care and good night.